Welcome back once more to the broadcast. Our analysis of the Supreme Court, the presidential election petition before the highest court in the land continues here. Of course, we will be keeping an eye on this the whole day. Remember, at 2 p.m. is when the Supreme Court judges are expected to make a ruling on the applications made yesterday during or last night in that night session during that pre-trial conference. Then exactly at 3 p.m., that is when the petition proper begins. And we have been talking about some of the issues raised last night. But before we get to the issue of the Friends of the Court, let's talk about the story that is, of course, on page 6 of the Sunday Nation, and that is NASA says it will expose IEBC fraud. And this is concerning evidence, it says, comprises missing or questionable security features in Forms 34A and B, and of course saying that a total of 16 constituencies whose barcodes, according to NASA, display names of other places and not the constituencies. And we have established, of course, in this discussion in the last few minutes that this is part of those affidavits that NASA says they go hand in hand with the written submissions of the petitioners Raila Odinga and Kalonzo Musyoka, but were filed out of time. Mutinda, I didn't get your views on this particular issue.
On the issue of
this evidence that Disma says it's not very new, but it was filed out of time, but it's, according to NASA, it could change the complexion of this case totally.
I gave an overall position that it is really going to be left at the discretion of the judges to decide what to admit and what not to admit, because it cuts across board that both sides of the case have got issues to do with things, the timelines that have been brought, affidavits that have been brought late, and servings that were done beyond the deadlines. And that is really going to be at the discretion of the judges to decide what to admit and what not to admit. What I had said is that if they decide to admit anything that had been brought outside the timeline, then it will mean that the issue of timelines then will not apply to everyone. So whoever did anything late, then it will be admissible. And the opposite is also true. If they decide to lock out anything because of time, then that will apply across a board. And you know, as important as it is, at the end of the day, there has to be an objective way of doing things, such that it doesn't look like they are adjusting to favor any party, because that is what is in the interest of justice. So whatever position they are going to take about what was brought outside the timelines is going to apply to all, and that is my views on that particular issue.
Hesbon?
Yeah, I think the argument that I heard from, NASA's lawyer, Otiende Amolo, was that these applications that they're seeking to be admitted are not really an expansion of the petition, but are essentially part and parcel of the pleadings that they have. And I want to believe that if the judges are going to make a ruling, just like Mutinda is saying, they're going to be alive to that to what extent is this new evidence that the respondent is being ambushed with, and to what extent is it just part of the pleadings that the petitioner is making. And if essentially they are part of the pleadings that are already filed by the petitioner, then the issue would be why they filed, as affidavits late. And just like Mutinda is saying, I mean, it's a question of the discretion of the court within the wrappings of justice. Because again, we cannot talk about public interests because justice in itself presupposes that the Supreme Court is meting out justice in the interest of the public. So it's a bit interesting, how this will pan out, because there is that perception that if they admit it, then there are people who will perceive it as, giving undue advantage to the petitioner. And if they are not, then the petitioner will also have an issue and say that, I had critical evidence that was knocked out on technicality. And again, that will be taking us to the whole electoral process. I mean, an understanding of the whole electoral process is in itself very important, that technicalities should not be the basis upon which we get something that is likely not to be accepted by both parties.
All right, another issue that these are...
Just allow me to make a point. This is an extraordinary petition. with an extraordinary petitioner, extraordinary respondents, and extraordinary lawyers. Now, these extraordinary lawyers should be able to respond to extraordinary situations without wandering, without sacrificing technicalities. And they should know that we need extraordinary justice from these Supreme Court. And those judges are equally extraordinary. So they should do everything guided by the rule of law and order, but in the interest of Wanjiku.
All right. These are all issues that we expect the 7 judges to rule on this afternoon at exactly 2 p.m. Another issue that Kenyans will be paying attention to listen to is the applications by various individuals and institutions who want to be enjoined, in this case as friends of the court, led by Chief Attorney General Professor Githu Muigai, as well as other institutions, the Law Society of Kenya, the Information Communication Technology Society of Kenya. There's 2 former presidential candidates, Professor Michael Wainaina and Dr. Ekuru Aukot, who had initially conceded defeats. I don't know, what is your take on these applications and how important are they to the case? It's Amicus curiae.
Well, you know, the basic understanding of a friend to the court is somebody who comes to offer extraordinary opinion, an opinion that is not ordinarily resident with any other person. Like, for instance, for the ICT Society of Kenya, that will be extremely important because one assumes that those friends of the court are going to represent ICT professionals who should be in a position to give an independent view. So that one would be welcomed almost instantaneously. And also the Law Society of Kenya. All the people in that court are members of Law Society of Kenya, apart from judges. So they should be given an opportunity. But the interesting bit is the one for the Attorney General Githu Muigai. That NASA claims that in the past, when Githu Muigai has been admitted as a friend of the court, he's actually not been giving an independent view. He's been partisan. He's been leaning towards one particular interested party. But in as much as NASA is nervous that Githu Muigai may be admitted, but I think in his capacity as the Attorney General in Kenya, he should be given an opportunity to give his views as a friend of the court. And if NASA has got an issue, then since they've got all these politically connected lawyers, all of them with a primary interest in this matter, they should be able to react. However, you've got other people who are doing this for showbiz or because they want to win favors. Like, for instance, I was at pains to understand what Mr. Charles Kanjama wants to represent in that institution. And one would have expected that he should have even retained another lawyer to present his prayer or to present his application. But he did it in person. And the same applies to Professor Wainaina. So there are some people who are coming not because they want to add to the jurisprudence, but maybe they want to be noticed. You know, this is a case everybody is paying attention, and there's a high probability that some people are looking for work and using the Supreme Court to look for that opportunity. Those are the kind of people who should not be entertained because of the urgency of time.
Prof, so the fact that the Law Society of Kenya was an election observer, should this, and there's a lawyer, a member of the Law Society of Kenya who has already opposed LSK's application to be enjoined as a friend of the court. What is your take on this?
The way LSK is established and the context in which it functions, it is a protector of the public interest. That's really a platform on which they are able to provide legal support, guidance, and sometimes protect the decision-making process at various levels. Now, for me, they can have quarrels among them if they were observers. Did they look partisan? If they didn't look partisan, why not? For me, the strongest case is that they are a statutory institution that represents the public interest in public matters. So to me, they should be allowed. The ICT Society, in a similar manner, is offering technical support, which is core to the interpretation of evidence provided in this case. So the expertise that they bring along is essential for, could add value to the judicial process. 3, if you look at the AG, personally, I think I have no quarrel with the AG coming on board, if only he would play the role of an AG for the public interest, not an AG for either party. All right? As a he's the Attorney General for all of us. He's not an Attorney General for 50%. So in my view, I hope he has submitted that as one of the reasons that he's using to come on board as Amicus curiae. There is an interesting thing about these people, the presidential contestants who had already conceded and basically closed their participation in the legal process. Now they are coming backwards, and they seem like they have been hit by divine intervention. God's hand is saying, if you come back here, then you provide relevance. Now, from my perspective, I don't see what relevance they're bringing on board, except the relevance of trying to make themselves, all right, politically relevant again after they had been swept by the electorate into oblivion. So in all, Ben, my feeling, other than the election losers who had conceded, my view is that the Attorney General, the ICT Society, LSK, and that particular group should be admitted. The election losers, in my view, I'm not sure about their relevance.
All right. Mutinda, what is your take on this, friends of the court?
Yes, I think in deciding who to admit as a friend of the court or an interested party, what the judges need to look at mostly are two things. There are the rules guiding the admission of such in Supreme Court cases, and then there is the time constraint. Because I think it would really be unfair to the main parties to this suit if so many other amicus curiae are admitted and interested parties that are coming to eat into their time. So for as long as they can create a good balance that ensures that the time that is needed for prosecuting this case by the main parties to the case, that is the petitioners and the respondents, if the amicus and the interested parties are going to be brought in a way that does not affect the time of the rest, I'm okay with it. But if they're coming to eat into what ordinarily should have been time for the main parties to the suit, then probably have a problem with that. So that should be the balance they should strive to strike in deciding whether they are going to admit this many amicus curiae and interested parties or not.
Right. I think admission may not just mean standing there to argue the case, may be being permitted to table evidence, which may take 1 minute, which may take an hour. So at this particular point, we would be judging upfront that these people want to come and participate as major players in the petition, when in fact they are minor contributors. What I'm thinking about with respect to the use of time is the fact that these people want to be allowed access to the proceedings so that a way can be established in which they can contribute without necessarily compromises the time given to the major players.
If that balance can be stricken, then that's my opinion, then I would have no problem with whatever interested party or amicus curiae that is enjoined, for as long as the rules are obeyed and they allow such.
Thank you.
All right.
Yes.
Husband, who are the most important friends of the court, according to you?
I think friends of the court are very important, and you'd assume that from their submissions that all of them are important, and it's unfortunate that we are going to get a ruling without hearing their oral submissions. But I think two issues are critical here. One, in their submissions, what exactly are they bringing to the court that the court does not already have? You know, we can have a case for the Attorney General that this is the chief legal advisor to the government. So there is an aspect that is bringing that is assumed to be in the public interest, which I guess NASA has a contention with. based on the past experiences. But then you look at the other submissions, you want to ask yourself, what is the LSK bringing? What is Charles Kanjama bringing that is different from what LSK is bringing? What are the two other applicants who want to be enjoined as petitioners and as respondents bringing into the case? And is it adding value? Now, if it is adding value, I think the second thing that is important is it in the public interest, especially for the friends of the court? Because these friends of the court are supposed to be non-partisan. So I guess what the judges are going to be looking at is what value are they bringing on board? And then secondly, to what degree are they doing this in the interest of the public and not serving the interest of either of the parties, which I think, to me, is very critical. And if it were for me, technically, I would only admit the ICT society and leave out the rest.
All right. A lot of issues to discuss, but of course, in the next few days, the next 2 days, we shall be seeing those epic battles between those legal teams for the various, the petitioners and the respondents in this presidential election petition, of course, challenging President Uhuru Kenyatta's re-election in this 2017 general election. And one thing that some people have pointed out is, of course, people will be focusing on the legal teams as well as the bench itself. Very many comparisons being made between the 2017 petition and the 2013 one. And one of the key persons, of course, is the President of the Supreme Court, Chief Justice David Maraga, who did criticize the 2013 process in some personal opinion that was published in a book called Balancing the Scales of Electoral Justice, where he said the Supreme Court failed to address mismatches between Forms 34 and 36 and the issue of rejected votes. I don't know if such opinion, dismas, would make him to be necessarily under much scrutiny as he, leads this particular case now.
Well, whether or not he made those statements, right now Justice Maraga, and indeed the entire bench, is under scrutiny, heavy scrutiny, because there's a lot of analysis on their leanings. We are now using the American model to try and understand, are they liberal, are they conservative, where do they sit? Do they sit on the fence? Are they likely to make a ruling? But Justice Maraga comes in this bench, or in this matter, with a very rich experience. You recall he practiced as a lawyer in Nakuru before joining the High Court and going to the Court of Appeal. And most of his rulings or judgments, there is not a single lawyer in Kenya who can dispute his work. If you want to appeal on any ruling he's made or a judgment, it's because you want to buy time in the interest of your client. It's not because of a lack of clarity or his reasoning or his capacity. And even before he became the Chief Justice, you remember he was working closely with the National Assembly and the Senate to review the petition rules. So I think in this matter he's eminently qualified. And if there's anybody who has got issues with his prior judgments or his other statements, then they can raise them before this panel. And there's no doubt in my mind that he's going to serve the best interest of the nation. Even from last night, the way he started handling the matter, you would see a judge who is very strong, who cannot be intimidated by anybody, who cannot even be intimidated by what is done in the past. And you recall when he was undergoing vetting, that some people accused him of corruption. And he said that I'm an elder of the SDA Church, I'm very strong in my morals, and I'm willing to take the Bible and swear that I've not taken a bribe. I think that's extremely important. And anybody who's got any issue, this is the right place to raise those issues so that you clear the air. And I don't think that is past. If anything, is going to enrich their contribution. Mm-hmm. And it would be interesting for NASA or Jubilee or President Kenyatta's legal team to use his ratio decidendi in the past as a key factor in determining how they make progress. And another person who was very strong, who shows that, in fact, the Supreme Court is independent and is likely to make a very solid ruling, is Justice Mwilu. You recall when the Attorney General was attempted to make suggestions on how they should make progress, she was very firm and categorical that do not have mercy on us. We've got our calendar and we know how to make progress. And for many Kenyans who've been saying that they think that Justice Mwilu is a bit soft, yesterday they saw somebody who has got a cool exterior, but I think she's made of steel. She's an iron lady.
All right. Prof, I know you've seen Chief Justices come and go in this country. even as he pointed out the omission by the 2013 Supreme Court judge bench, in that opinion, CJ Maraga noted that scrutiny, such as the one that has been requested by NASA, is not an automatic right to be granted as a matter of course. Of course, that is, he finds himself in exactly the same position. It's gone full circle. What do you think about his leadership and the bench in its entirety?
First and foremost, it's quite clear from what has come out of the Chief Justice into the public domain that he is a man of convictions. Mm-hmm. Once he has looked at what is available, he makes decisions, and his decisions are guided by principle. That I don't think is a matter for dispute now. But the issue that we are dealing with here is that he is looking, for example, if a request is made for scrutiny, he's looking at reasons for that request. In other words, if you make a request which appears justifiable, but the evidence you provide, the reasons you provide for making that request is not adequate, is not sufficient, does not stand alone or in conjunction with other evidence, then of course you look at it independently. Two, there is, to me, what he has said about several issues vis-a-vis previous judgments suggests clearly that we know where he's coming from. All right? The key thing in the Supreme Court should not be what appears like their principles guiding each individual are unique to themselves. They are hidden. In other words, we don't know exactly what principles guide the judicial decisions of each of the judges, other than a general blanket view that you expect them to be objective. When he has stated his position, and as Mukua said, using the American model, one would expect us to look at the other judges against that yardstick. Now, in other words, he stated a position where he comes from in terms of viewing and reviewing available evidence. Are we able to use that as a yardstick to assess where the other judges are likely to be coming from a point of view of principle, not a point of view of suspected affiliation or vested interest?
All right. Mutinda, what do you think about this previous? Was a personal opinion.
I think that can only be used against him, if at all, in the case that indications are that he has given a ruling not guided by the position he gave in that book. As at now, the jury is still out there, because since he gave that opinion, this is the first time they are handling an election petition. So what keen observers should be more interested on is to see whether he's really going to apply the same standards in making judgment in this particular case. But the most important thing is to know that this is a 7-judge bench, and that that opinion is not necessarily binding on the other 6. And so those critics who would want to hold him accountable on what he previously said and is on record should probably be keen on what he is going to give. Because you see, when there are 7 judges, then there is, unlike in 2013, and people have brought that out. I even heard NASA say that this time they would want to look at each individual judge's ruling before they get the final ruling of the entire bench. Then in that case, if they have that opportunity, then what they probably need to be looking at is the kind of ruling that the CJ will give vis-a-vis the position he had taken in that particular book that you've quoted.
All right.
Yeah.
Husband?
I think when people start digging, the rulings that the CJ has made in the past, the publications, it's also important to situate it broadly, because I think in the same publication, he also talked about, access to information and fishing for evidence, which are two distinct things, that you cannot ask for access to information if you don't have a particular type of information that you're looking for, and therefore you subject everyone to a fishing expedition in the hope that you'll catch some fish. So to the extent that he has done so many things, we basically need to come back to what kind of a person he is. He's a person of moral conviction, very religious, and just like Mutinda is saying, this is a 7-bench, judge, and therefore putting them under a lot of pressure is unnecessary in terms of what have they done in the past. Therefore, we need to hold them onto what they've said in the past. I think each case has its unique peculiarities. And in as much as he talked about these forms, you may want to ask yourselves, in this case that we have today, an interrogation of these forms, will it fundamentally have a serious impact on the outcome that you were given? And therefore, could that really depart from the rulings that he has made in the past? And therefore, are we able to understand the ruling that is made given the circumstances that we have at present? And to me, I think that is the most important thing, that we need to situate things within the circumstances that are prevailing now against the circumstances that were prevailing back then when certain rulings or certain pronouncements were made.
All right. Another thing that many people were talking about during last night's pretrial conference is the fact that this is a very, it's a case which could have, technology and ICT-related issues being very central to the case. Yet it did seem that the judges are not very well conversant, even the legal team, with ICT issues. I don't know what gives here, Dismas. What should happen?
My understanding of this ICT thing about the forensic audits, which in my view is going to be a turning point, would demand that Jubilee needs to retain the services of forensic experts who are solid professionals who will give a view which is not politically correct. And
Right.
NASA needs to do the same thing. They need to retain the services of forensic experts.
All right, and
then
of course, Dismas, if I can interrupt you, those live pictures, those are live. We have live pictures from the All Saints Cathedral, where the petitioners, that is led by Raila Odinga, the presidential candidate for NASA, and Kalonzo Musyoka, and some of the co-principals of the National Super Alliance have been attending church service at the All Saints Cathedral. There you can see them, live pictures there. From there, of course, they'll make their way to the Supreme Court. There's supposed to be a public appearance by Raila Odinga and company as they await, as their legal teams await for the hearing to begin this afternoon at exactly 3 p.m. Yes, Dismas.
Now, in other jurisdictions, for you to become a lawyer, you must have another qualification so that law becomes a secondary qualification. And that's why you would have lawyers who are very solid, who are subject matter experts. But in the absence of that, then one would expect Jubilee and NASA to have very solid ICT experts giving them advice. But more important, it's for the 7 judges also to benefit from the same. They should retain the services of ICT professionals so that before they sit down and do their judgment or do their rulings, they're able to benefit from that resource. Because in the absence, they may make a decision which is not anchored on the ICT technologies.
Mm-hmm. Prof? What is it?
I agree entirely. In fact, there is a case, a historical case of the late senior advocate, Jojadis, who had a medical background and the law was a second degree. So when it came to specific legal issues in court, he used to beat the doctors all over the head. He would ask technical questions. I remember one case where he simply said, you've said that the bullet entered through the thigh and exited through the knee. Then he said, can you briefly describe the muscles in that area that would be able to determine the direction of the bullet, the trajectory, the exit trajectory of the bullet? Now, the doctors had forgotten the details about the muscle structure in that part of the body. Now, I'm using this case to strengthen the argument that, as far as I'm concerned, the ICT team, acceptable both parties, should have been put on standby to be able to offer technical advice to the court, particularly to the judges, to the bench, because the bench has not had a chance, I think, to play around with the electoral matters that IBC has been playing around with, and also the two protagonists. So my view is that technical expertise, ICT technical expertise is central to the determination of this thing. If it is badly managed or the information is inadequately processed, then we are likely to have people cry foul. So the essential part of this petition is the ICT. In fact, if you look at almost every part of the process, after the voter had cast their vote, everything after that is more or less electronic.
All right. Mutinda, how does Maraga incorporate ICT in this case, seeing as it seems to be very important?
Clearly, from yesterday, it was very clear that they are not authorities in matters of ICT. And that was from both the bar and the bench. And it actually probably took the intervention of Otiende Amolo to clarify what Senior Orengo was trying to say, because he probably didn't bring it out as well as Otiende, who's much younger and probably IT savvy, would have wanted it brought out. And I saw him intervene and probably put it better than Senior Orengo had done. But the question which I would, I want to differ with co-panelist Prof here, because Prof says that everything else other than after the voting was electronic. That is not necessarily true. I actually happened to have been one of the presidential agents in one of the 290 constituencies, and I witnessed what actually took place. And that is the truth of the matter, that at the polling station, every polling station, after the close of voting, there was the counting of votes. Once the counting of votes was done, now depending on what seat, we are now focusing on the presidency, the Form 34A is filled. Once it's filled, there is a copy that was being given to the agents. And then there was the original copy that is retained by IBC. That is the PO. Then at the constituency where I was a chief presidential agent, now all these Form 34As are now brought from, actually in my constituency there were 221 polling stations.
Right.
So now all their Form 34As were brought and were tallied into Form 34B. I have, even today, a copy of that Form 34B. So my concern probably would be to check what NASA has or what IBC has given and compare it to mine in my particular case. And I would guess that is what should be done in all the 290 constituencies. I still don't see the role of ICT in that.
You still don't see ICT?
Because what I want to illustrate is this.
Yes.
Let's say, for instance, that you have hired me to carry your 10 sacks from Kisumu. And then when we get to Nairobi, there are 9. And you can confirm that when they left Kisumu, and whatever documents we used in that transaction confirmed that they were 10. Then when they get to Nairobi, they are 9. Of course, there is a clear case there. Are we to get it? What I'm trying to say, that there is one thing that lost here. Right. So what NASA should be focusing on is what the discrepancies from what. Because now ICT, I'm trying to get where ICT is coming from, because I have told you what was happening physically. So in the Form 34As, 34Bs, 34C, we have evidence that what you people used to declare, His Excellency Uhuru Kenyatta, is not in tandem with what our agents were given in certain polling stations and certain constituency tallying centers. Then we would see a case. Because where exactly does the... And the IBC has repeatedly stated that for purposes of declaration, they did not use the results that were being transmitted, but rather relied on the physical copies of both Form 34Bs and 34As. And their lawyer has clearly made it an open thing that they actually don't even mind giving copies of the original. So then where is this centrality of ICT coming in? That's what I'm trying to get.
All right.
Yes.
Let me get Hesbon's view, then I go to Dismas.
I think ICT is central in the sense that what was actually declared at the constituency level and at the polling station level was relayed via technology. And to that extent, you'd want to understand what exactly was relayed, and is it the same as what was declared at the constituency level. Now, the sacrosanct position of Form 34A and B remains, and to that extent, you cannot say that Form 34A and B are not authentic and are not really necessary in this case. But the question is, if the petitioner himself is already questioning, the authenticity of these forms, then what is the fallback? I think the only turning point for us to authenticate all this is to go back to technology and ICT and go back to the server and ask yourself, now, if these are the originals, is this what was relayed? And if there is that perception that whatever was relayed was actually relayed even before the generation of these forms, the server is going to tell us the timings, which is very critical in this case. And I think that is the point that the centrality of ICT occupies. But again, from the question that you asked, now, people seem not to be very adept in matters ICT, yet it is becoming central. You realize that there is a sense in which the whole thing is becoming a question of ICT becoming central in terms of making this case a lot more amorphous. You know, you have one side of the defense team talk about this many hours. The other side of the defense or of the respondent defense team talks about many number of days.
All right.
And that is where now you want to bring in the IT experts, you know. And the question would be, are these IT experts going to come and prosecute their verdict on the basis of the interest of the public? So much so that we know that whatever they're saying is authority. And they're not stating it from a position of we want to win this case or we want so-and-so to win this case. And I think that is what we are seeing in the lawyers, that the lawyers for the petitioner are actually making it look like it's a very simple process. And then the lawyers for the respondent are actually making it look like this is a very tedious, long process, and it is unnecessary within the timelines, which, to me, basically means that an IT expert, you know, of integrity is necessary.
Needed.
Yesterday, there's something that the CJ asked when some of these requests were being made. Are there specific forms from certain constituencies or polling centers you would want, or do you want all of them availed? That question already leads you to the matter that you are raising about fishing expeditions. Because if clearly you want all of them, it is a fishing expedition. Because you should be saying that from my agents in Embakasi South, for instance, where I was a presidential candidate, what was brought to us, and we had all NASA agents there. At least I was nowhere where we didn't have a NASA agent. What they brought to us is not what has been used to do the national tally, and want to pick certain so that they can.
But if it does not corroborate, if it's not in tandem with what was given out electronically, shouldn't that be?
No, the question then remains. No, the question then remains is this. The question that remains is what was used to make the final declaration. And because that's really the question here. And IBC has repeatedly come out clearly that it is not what was transmitted that was used to make, because you remember it was questioned midway, and they had to make clarifications publicly from Bomas that actually before we make, and that was the main reason why there was delay in making the announcement, because after queries were raised, they now made it clear that they are going to rely on the hard copies because of the queries that had been raised to make the final declaration. And that is what happened. How then does what was transmitted affect the final declaration? That's the question here.
But let's use Kavemba as an example. You said that you're transporting stuff from Kisumu to Nairobi in 10 sacks. Now, if you get 9 sacks in Nairobi, you question where has the one sack disappeared to?
Yes.
But that's not sufficient. You want to be sure that if the sacks were containing beans, it's actually beans in Nairobi. It's not a maize that has landed in Nairobi. And when the results started streaming at the portal, and you recall there was a demonstration at Bomas of Kenya where they said everything was going to be captured, everything was very solid. Now, the chairman of IBC makes a quick U-turn, an emergency U-turn, and he says, wait a minute, what you saw on our portal was merely statistics. Now, the question people would like to establish when they socialize with the server is, where did these statistics come from? And NASA agents claim when the decision was made, there were a number of forms 34A and B missing. They did not have access to those forms. Now, NASA is making accusations, Jubilee is making accusations, and IBC is making accusations. How do you reconcile these inconsistencies without going to the raw information, without auditing this server? It may just be the case that NASA is making allegations which are not founded. But it's important for this extraordinary matter to dismiss those allegations by allowing people to have that access to the server. And in my view, this server should not just be given to NASA like a blank check. It should be structured and supervised by the courts. Because Issa Mansour raised an issue that if you give NASA the opportunity, they may go and collapse the system and play around and, maybe even infect it with a virus. So it should be structured, coordinated by the courts. And you recall during the last election, when court had issues with a number of ballots, the Supreme Court ordered that there was going to be recount and review of some specifics, but supervised by registrar. And maybe that's what needs to happen today, so that when they make this extraordinary ruling, every person goes up a happy man. And on Saturday or Sunday, we should be able now to say that everybody in Kenya has accepted and is moving on, anchored on the rule of law and order, that all information, whether it's a resident in Safran in France, or it's in Kisii, or it's in Suna, where Osborne comes from, has been placed on the table. That we've been flooded with so much information, and one of the things that the judges need to say is that we were given so much information, beyond doubt, this is the winner, this is the loser.
There's something I want to protest, is the use of my example in a twisted way, because that is not what my example meant. The question is this, that if we have a dispute in Nairobi about how many sacks we got from Kisumu, we go back to Kisumu so that we establish exactly how many sacks were loaded, so that then we can know where did this disappear. And if then that is, you establish a case, then it is clear we loaded 10. Why are there 9 in Nairobi? That's what I was trying to say. And that is my point of reference for Form 34As and 34Bs, that what you people sent in Nairobi is not what we got from the actual polling. That was my example. It was not what we got from the actual polling centers. And the way we are proving that is by comparing what you sent to Nairobi with what we got from the POs and the returning officer. They've not done that.
The only difference with your example is that there's no electronic
No, in this case, the vehicle is the transmitter. In this case, the vehicle is the transmitter.
And in this particular case, in my view, Ben, Kavemba is trying, they say give a dog a bad name and hang him. He's trying to hang the ICT system without its questioning its utility value in the system.
It was not the basis for the final decision. That's why
as far as I'm concerned, I want to object to the example that he has given. It is common knowledge in the business sector that when you load your goods from Mombasa to Nairobi, there are thugs on the road that normally will stop the vehicle, empty it, and fill the bags with the stones. And then when the vehicle gets to Nairobi, instead of it's carrying bales of cotton, it's carrying pieces of rock. Now, this is the aspect that the ICT system was dealing with. In other words, while the main portal was carrying whatever it was carrying, what they're trying to establish is, were there subsidiary entry points and exit points as the information was being transmitted? And in my view, I find it, in fact, impossible to explain how Kavemba arrives at the conclusion that leave out the ICT system out of this case. In my view, doesn't it smack of unquestioned manipulation?
No, the question is this. Let me be very clear. Because for purposes of this discussion, if the declaration of the results by the IBC chair was on the basis of the transmitted results, then we would all be in agreement that we need to verify whether what they used as transmitted was what was obtained from the original source. But in the case where that is not what was the basis for making this declaration, then I wonder why we want to make it so central to the determination of who won this election. Because the IEBC itself has made it clear that it was not the transmitted results that they used. If, by the way, if that is what they'd used, we'd be at par. And all the questions you're raising would be very valid. I want to ask. But when it is clear that the IEBC did not rely on the transmission, it actually relied on the physical Form 34As and 34Bs to come up with the 34Cs. That is why I'm questioning the centrality.
Let me throw a spanner in the works. Before you do that, let me throw a spanner in the works.
Yes.
You know, in this case, NASA is bringing other evidence saying that they can't trust those Forms 34A and B. Barcodes are fake and all that. So it means at the end of the day, you have to look at the electronic system of transmission, transmitting the results, as well as the Forms 34A and B.
The question...
Because they are casting aspersions on the physical Forms 34A.
And I guess that is why they are asking for the originals. If I got it right, yes. I guess that's why they're asking for the originals. Right. So that with the originals, then they can probably now have a more watertight case regarding the issues they are raising about. Because when you don't have the original, it is possible that the paper that was used to make a copy is the one having issues. But when you have the original, then the original has the security features as agreed and are set out.
And you don't need the ICT.
That's the difference. No, you don't need that. That's the barcode reading. They were very clear.
Yes, Prof.
The question I wanted to ask, Kavemba has asserted rather strongly that they used, the original forms to make an announcement that Kenyatta had won the election.
Yes.
Is it correct to say that those original forms were available at the time making the announcement? What I've understood all along is that IBC has been fishing for these forms until this week.
At least the 34Bs were there.
Just a minute, until this week. If you have 34B, 34B are the children of 34A. So if they are children of 34A, then, and 34A is not available, then clearly...
They've said they have the forms.
Then they have
even
forms,
willing to avail them.
They have forms 1 month after the election.
But Ben, let's go back to what happened at the Supreme Court yesterday.
Yes.
And what Kavemba says raises a lot of issues for concern. When Senior Counsel Paul Mwite behaved in a manner suggesting that IBC would not have a problem giving this primary information from 34A and B, Lawyer Ngati requested for an adjournment to get instructions from his client. Why did that have to happen? And in any event, if from Kavemba's perspective, that it doesn't matter what is contained in that server, then why can't it be opened up so that every Kenyan, when Jiko confirms that there is nothing to worry? Because you see, this extraordinary petition requires to settle people. That on a Friday evening, when the Supreme Court pronounces itself, everybody goes back home without an excuse. So there's no reason for us to start creating some challenges, putting landmines in the process of us getting the necessary information you need to take a decision.
The question is not that it doesn't matter. The question is that it does not impact on the declaration. Yes, that is just the question here.
But
it's not that it doesn't matter. Because at the end of the day, probably there must have been a reason why it was sidestepped.
And those are the reasons that must be established.
That's what I'm saying, for posterity, not for purposes of determining who is the president of Kenya at this time. That's the difference we need to establish here. There are things that we need to do for posterity, so that going forward, we do not have gray areas. It's a black and white issue.
Right.
But for purposes of determining who won this election, some of these are side issues. That's what I'm trying to say. It's not like they're not important.
No, but
they are not at the core of determining whether His Excellency the President, Uhuru Kenyatta, was rightly or wrongly declared the winner. That's what I'm trying to say.
But I think, Kavemba, there is a perception that the declaration was made even before all the Form 34As were availed. And just like Prof has said, Form 34B is generated from 34A.
Yes.
So in the absence of Form 34As, then it is very difficult to understand how Form 34Bs were generated. And I think if we go back to this affidavit that says that the declaration was made even before these forms were availed to the NESA agents, then it calls for an interrogation, not just of these forms, but of the system. Because if you perceive a situation where these things are not generated from the forms, then they must have been generated from somewhere. And if they were generated from somewhere, the suspicion takes you to the ICT infrastructure, and that is the server. And again, coming back to what Dismas said, I mean, what is so difficult in availing the original forms? Not for the determination of the winner or the case. The question is, going forward, we need to have an understanding. We need to have an understanding that these things are in the public domain. When IBC says that they'll be in the portal, they'll be scanned and forwarded to the portal. And if you want the hard copy, it is only a court of law. And that is what NASA is asking, that the court compels these guys to avail them.
And IBC have no objection.
Now, IBC has no objection.
Let's
but
be clear
there was
on
an
that.
objection.
Yeah, but
Not from the IBC.
But Jubilee has an
you
objection.
can't accuse IBC of other parties objecting. Them, as an institution which is independent, have publicly come out clearly that they have no objection. That's the point.
But remember, the question is, why would Jubilee have objections on the production of the primary
you
source
won't
of
determine
information?
how Jubilee is going to prosecute its case. That's theirs. That's why they are a party on their own. But IBC,
but you know, you're a Jubilee strategist.
You can hold. That's why I'm speaking as a Jubilee strategist.
All right, if
that
this is an
we all know
indication-
and an explanation as to our strategy in this case.
If this is an indication of how that those hearings will be going, then Kenyans are in for an interesting time. But as we wind up, maybe just what are the other things that maybe Kenyans missed? Of course, we'll keep an eye on these issues, but we have seen a lot of tight security, some streets near the Supreme Court of Kenya building being cordoned off, very heavy presence of security personnel. The judges of the Supreme Court dressed in red rather than green. Some of the things that we did see. I don't know, just very quickly as we wind up, Dismas.
You know, when Justice Mutunga came, he came with to sort of disrupt the entire system. So he came with his green uniform. But I think Justice Maraga said, let's go back to the normal ceremonial robes. But I think the departure, I mean, unlike last time where you had judges who are handling a petition for the very first time, for this one, the bench has got the benefit of history. But the amazing thing, and Professor Ungeri mentioned it Professor Tumbo mentioned it in passing, is that for NASA, they've decided to retain the services of lawyers who've got insurable interest in this matter. You know, if you don't own a car, you can't buy insurance. But for these lawyers, when you look at Orengo, Kaluma, Otienda Molo, all of them are senators-elect or MPs-elect. Who've got of course, Magaya obviously is he was part of that campaign. So one can easily form the conclusion that in this matter, not because they want to generate a fee note, but number one, they believe in the presidential candidates, and their presidential candidates won. And number two, they've introduced politics. Most of the time when James Orengo will be speaking, he will not even be addressing the judges. He'll be addressing NASA supporters, or probably addressing his voters in Ugenya. But for Jubilee, they've decided to go for lawyers who do not have, or rather lawyers who have not participated in competitive politics. That's Ngatia, as well as Aben Nasir. So you'll be able to see that if you go to the Supreme Court and you are being retained as a lawyer, for a fee note, you'll be paid whether or not you win. It's like you're going to perform a postmortem. You're going to be paid if you are a medical doctor, whether or not it's a success. But for the NASA team, they've got a primary interest. But again, when you look at those lawyers, one who stands out, and in my view is going to be the next celebrated lawyer, is Dr. Amolo. Because it seems like he's the one who is anchoring the entire NASA case. While on the other hand, you have Ngatia, who seems to be anchoring the Jubilee case. But what is interesting, if you read Paul Mwite's body language in his presentation, I doubt whether he's loyal to any of these parties, but the public interest. And I think he's probably also going to be a key feature in this process.
Prof, what is the one thing that maybe Kenyans missed in this?
The one thing I think that Kenyans missed before we got where we were, there was essential information that IBC should have given in terms of the implementation of the election as a project. In other words, the framework should have had phase 1, activity 1, 2, 3, 4, phase 2, 4, 5, 6, phase 3, so that they would have a check-off system whereby by the end of the day, they would be asked, did you comply with your own framework for implementing this project? That's one thing that as citizens we were not told. Two, there was something that occurred that was rather strange. The government was behaving like a carpenter who has a hammer. Anytime he saw a nail, security was hitting at a nail anywhere and everywhere, irrespective of whether there was a breakage of the law or not. Now, this is something most people were not prepared for. In other words, the security agencies were behaving, all right, like people who an event was going to take place that was going to elicit a violent response so that they got over-prepared for that response. When the response was not available, they became carpenters. They were hitting anything they saw, and they thought it was a nail.
All right, interesting. Thanks, Prof. Mutinda, what do you predict in these hearings? What is that one thing that stood out for you?
No, the beauty of the whole thing, and unlike my co-panelist, Dismas, who thinks that it is unfortunate to our democracy, I'm of a contrary opinion. This is good for our democracy, for constitutionalism, because even in the most developed democracies in the world, some of these electoral matters end up in court. You know, there was a dispute among the immediate ended U.S. election. There was the issue of whether Russia had hacked into the system or not. You remember there was the Al Gore case that actually ended up at the Supreme Court. So I'm wondering what is embarrassing about our matters ending up in the Supreme Court if democracies that are more than 200 years old still end up their matters there. For me, I think it is good for entrenching constitutionalism, for democracy, and for testing our institutions. We created institutions for a purpose. It's good when they are tested and when they live up to expectations. Mm-hmm. And I think this is another opportunity for the Supreme Court. It is now becoming a common feature of our judicial processes. Right. Kenyans are starting to now appreciate the role of the Supreme Court. And to that extent, I don't see anything to regret. And what probably we need to urge our political leaders is to develop a culture of accepting defeat, so that when there is no basis for contesting election or results, then you accept. That probably should be the unfortunate thing, but not the matter going to the Supreme Court.
Thank you. 10 seconds of rebuttal.
Yeah. You know, now we are in the Supreme Court. I also need some 11 seconds. Now, we should be conducting our elections in a manner that when IBC says you've won, you've won. When they say you've lost, you've lost. And going to the Supreme Court in the presidential elections shouldn't be a best practice.
All right.
It should not be the norm. It should be the exception.
Fair enough. We'll leave it there. Hesbon?
I think I would go with Kavemba here, that this is something that is really good to our democracy. It's going to expand our jurisprudence. It is true that going to the Supreme Court is not really an interesting thing for an electoral process, but you may want to ask yourself, the rulings from the Supreme Court will then come back and inform our electoral process, and they will form a basis for the case laws, they will define our democracies, and probably what Kenyans should not miss after this sitting by the Supreme Court is an understanding of all the applications, all the proceedings, and a thorough reading of the verdict given by the judges, because it is that ruling that then goes back to improve our jurisprudence and our electoral laws, which is very important.
All right, thank you, gentlemen. That's where we leave it this morning. Thank you for being with me, political risk analyst Dismas Mokua, governance expert Professor Eri Tumbo, Jubilee strategist Mutinda Kavemba, and political analyst Hesbon Owila. Thank you so much. And we continue with our analysis of the presidential election petition currently at the highest court in the land. We have our team at the Supreme Court of Kenya, Sophia Wanuna and Rita Tinina, will be keeping an eye on things for us there this day as we wait. At 2 p.m., remember, the bench of the 7 judges of the Supreme Court will be making their ruling on the applications made last night in that pre-trial conference. And an hour later, at exactly 3 p.m., the petition proper begins. Don't go too far. Our managing editor, Joe Agio, is coming up next with another panel of experts, especially lawyers, to just take a look at the legal implications of this case, to just analyze what was said in that pre-trial conference last night and what to expect ahead of the beginning proper of the petition hearings. That's where we leave it. Thanks for watching. I am Ben Kiteli. Don't go too far.
This is KTN News.